I'm here and present and ready whenever you guys are ready.
Great, great. Give me 1 moment, please. Please. Okay, I apologize. Ms. Maynard, I'm gonna go on the record now. All right, this is the matter of Chad Murphy versus Artisha C. White, Utica National Insurance Group Republic Franklin Insurance Company and Georgia Farm Bureau and Mutual Insurance Company. This matter is case number 2025 CV 06187. This matter is on this morning for the unnamed defendant, Georgia Farm Bureau's Mutual Insurance Company's motion to quash. This hearing was requested by the plaintiff. Is the Georgia Farm Bureau ready to proceed?
Yes, Your Honor. Carl Britter here on behalf of Georgia Farm Bureau.
All right. Is the plaintiff ready to proceed?
Yes, ma'am. I'm Shane Hudson for the plaintiff.
All right. Mr. Brody, you may go forth with your motion.
Thank you, Your Honor. We're here on Georgia Farm Bureau's motion to quash plaintiff's notice to take a videotaped 30B6 deposition or in the alternative move for entry of a protective order. The plaintiff has noticed a deposition for a 30B6 representative or representatives of Georgia Farm Bureau that involves 23 broad-ranging topics and a request for 38 different species of documents for the same. We, at the outset, want to point out the procedural posture of this case because I think it should inform the court's decision here. This is a automobile accident case in which plaintiff has sued Artesia White. As part of that, they've also brought in the two different UIM carriers, one of which is Georgia Farm Bureau. Previously, plaintiff attempted to bring a direct claim against Georgia Farm Bureau for breach of contract and included in that complaint allegations regarding bad faith. Georgia Farm Bureau moved to dismiss that claim, which the court then granted. However, based on the 30B6 deposition, it appears that plaintiff is continuing to proceed with this case as though this was a breach of contract claim directly against State Farm and one in which they are entitled to seek a bad faith claim as well, primarily because of the interest in pursuing information regarding who made what decision when and why about why the claim of the plaintiff has not been paid. Pertinent to that, as the court noted, the key factor to even trigger the UIM liability in this case is a finding or entry of a verdict against the tortfeasor themselves. So we're not even, as I say, they're putting the cart before the horse as to being able to go down this road with Georgia Farm Bureau about the information that they're seeking. With respect to the standard, the court does have the authority to enter a protective order. The two requirements are that it be seasonable and also that good cause be shown in this case when the deposition that's being sought would result in annoyance, embarrassment, oppression, or undue burden or expense. We're seasonable on this. We filed our motion over a month before the deposition was noticed. And as detailed in our briefing, and as I would like to discuss briefly, the standards show that we have an undue burden present is here as well. As an initial matter, the obligation for a company to prepare for a 30B6 deposition with the wide range of topics the plaintiff presented is quite extensive. We have to identify the appropriate personnel with the knowledge. We have to gather and review the relevant documents and information. This would require coordination between different departments. It's my understanding that there will probably be two and perhaps even three people that will be necessary to cover the broad range of topics that the plaintiff is designated. Then there has to be an education on what the company's knowledge is on these particular topics. And then, of course, they have to be prepared to testify. This is no small task given the scope of what's being sought here. As an initial matter, and the way that we've structured this is trying to address the different requests in various groups. The first step we have here is that we really have a disproportionate burden on some of these requests, considering that there are much easier ways for plaintiff to get the information that they're seeking. That speaks to the request at 1, 2, 5, 11, 12, 17, and 22. These requests are primarily directed at policies, policy terms, coverage questions, records maintained by adjusters about the claims, the meaning and interpretation of any of that language. In this case, Your Honor, we provided the plaintiff with the certified policies. If there are questions about what the language of those policies means and how it applies to particular facts of the case, that is not going to be a determination for Georgia Farm Bureau. It is going to be a determination for this court. And this is not even a case where we have, some question about was there timely notice provided, and we would need to have an affidavit from someone at Georgia Farm Bureau saying, oh, I didn't receive this information or otherwise. the policy says what it says, and whether that's going to apply to this particular circumstance is going to be a matter of the facts that are presented before the court as to how the accident happened and what the court determines based on applicable law those policy provisions mean. So there's other ways the plaintiff can get the information they need about the policy and how it works and applies. Similarly, the plaintiff's also seeking communications with the plaintiff. That's at request number 3 and 23. All plaintiff is in equal possession of that information. There's really no need to try to designate somebody from Georgia Farm Bureau to come down and relay what plaintiff should already be in possession of. Turning to our second grouping of topics that are concerning, Your Honor, is that we would consider these to be irrelevant, overbroad, and unduly burdensome, primarily because so many operate at such a high level of generality that they're basically asking to do a deep depth inquiry into how Georgia Farm Bureau adjusts all of its claims and how it operates its business, not even tied necessarily to the particular circumstances here. They want to know about any changes in rule, policies, or procedures since the date of the incident and issuing this lawsuit. Is that talking about how they handle claims, what time people are supposed to clock in? I mean, it's so far ranging that there's really no way to respond to that. They're also looking for how policies are interpreted in general, underwriting manuals, and including any training associated with that. Again, Your Honor, the claim before the court is related to negligence, causation, and damages that were incurred by the plaintiff in regards to an accident involving the named defendant. All of these go so far beyond that they are, in fact, unduly burdensome on Georgia Farm Bureau in this case. Going to our third category of documents, which is 6 through 10, 13, 15, 16, 17, 20, and 22. Much of the information that's being sought here would either be protected by the work product doctrine or attorney-client privilege. Again, this is seeking inter-office emails, any sort of investigative work that was done, written and recorded statements that might have been taken, a copy of complete claim files. And again, going back to the seeking, the drafting, meaning interpretation of language found in the policy at issue. And the communications between intercompany personnel are going to be part of the investigative process. Also, necessarily, questions regarding coverage are going to involve legal opinions, which are something that we were protected by the attorney-client privilege. And the issue that you have is, in some senses, you might be required to be waiving some of that privilege in order to prepare these witnesses to go forward with these depositions. Also,
I'm sorry, I have a question.
Yes, Your Honor.
About that specifically. If a claims adjuster is making a decision about coverage, does that decision get discussed with an attorney generally?
Typically, it does. I mean, I would need to go back and review in the particular circumstances of this case, where that conversation happened in relation to communication with counsel. Certainly, I mean, that would be a topic of conversation that I would have with Georgia Farm Bureau regarding this.
I mean, before any type of lawsuit is filed, when they get the initial claim, when it comes in, hey, I've been in a car accident. I would like to use my coverage to pay these bills. Does the claim adjuster then say, let me talk to our attorney, I'll get back with you in their processing investigation of that claim?
I will say, in my general experience, that is not necessarily the case, that they go and solicit an attorney's opinion on every coverage determination that is made.
I think that all of our rates would skyrocket if that occurred.
Yes,
so I'm
certainly
glad to know that does not happen.
No, Your Honor, no. It'd be good for the
Okay.
bar, but certainly not good for
The consumer.
clients. So,
Mhm.
but I mean but the concern is that at least in this particular circumstance where you are in litigation, that's going to be an issue that's going to arise, and then parsing that out between providing, the general knowledge that will be associated with whoever's speaking on behalf of the company with the opinions of counsel that are intertwined with that, present a real concern about the need for this to go forward. Again, Your Honor, at the end of the day, we believe that these 23 topics and 38 requests for documents goes so far beyond what is reasonable and necessary for the plaintiff to get the information they need to present their case regarding negligence, causation, and damages. And at that point, even the coverage issue, because they have the policy information. Either the claim will fit within the terms of the policy or it won't, and that's going to be a decision that's going to be made by the court. what is apparent here is that plaintiff is presuming that they've already succeeded on everything, that they're entitled to coverage, and they want to go delve into the reason as to why they weren't, why the coverage wasn't initially granted, which, assuming that were to be the case, and this case were to go to trial and plaintiff is able to get a successful verdict against the tortfeasor, which would then trigger the condition precedent for coverage, then there might be a claim where they could go through and evaluate and ask an adjuster, why at this point in time did you not provide me this coverage? And that would all be a question of whether or not there was some claim against Georgia Farm Bureau that would be direct for breach of contract or for potentially bad faith is what I think plaintiff is trying to pursue. But again, we're not in the proper case or frame to do that, again, because the court has already said you don't have a breach of contract claim against Georgia Farm Bureau at this time. So why then would they be allowed to go through 23 different topics, many of which go far beyond what would even be needed to present that sort of claim in this proceeding? And I think it's telling even in the authority that plaintiff cites in their response, particularly the case of Chandler versus Liberty Mutual Fire Insurance Company, which is 333 Georgia Appellate 595, which they spend the most time discussing as authority for their ability to conduct this sort of discovery, is a bad faith claim against an insurance company after there'd already been a verdict against a resolution, as I understand it, against a tortfeasor. So again, plaintiff is putting the cart before the horse and trying to go through this sort of discovery against Georgia Farm Bureau. We believe it's unduly burdensome, not going to lead to discovery of, not calculated to lead to the discovery of relevant or admissible evidence. And under the circumstances, we believe the court should grant our motion to quash or otherwise enter a motion for protective order as to the 23 topics and 38 requests that have been presented here.
Miss, hang on. Yes, Miss Maynard, are you trying to say something?
My service over here, I've been trying to say something for a while, is very glitchy. I'm having a lot of trouble hearing you guys speaking. And unfortunately, that was during the duration of the whole entire motion. And so I'm having trouble hearing you guys.
Okay, I
it's
will.
Very, very, very choppy.
Don't stress too much. I am broadcasting this to the court's YouTube channel. And so I will get you that link so that if there's anything that you miss, you can fill in the gaps. I think that saves us here.
Thank you. Thank you, Judge.
Okay. So are you saying there's a problem with the internet?
Yes, the internet here at the courthouse is not allowing it to smoothly flow, so it's very choppy. It's hard to get full sentences.
Are you on the
and now you're frozen. Can you hear me?
Are you on the private? Yes, I can hear you. Are you on the private Wi-Fi or the public?
I am on the private.
You're on the private? Okay.
Maybe because it's storming outside, I'm not really sure, but it's normally not like this, but today it is really doing a number. So I'm doing the best that I can, but do know that it's pretty difficult to understand and hear on my end. So I just wanted to make that known.
Okay, let me just confirm that okay, I am on the live stream. That is going on. Yeah. Okay. Yeah, I'll send that to you as soon as we're done here. All right, Mr. Okay. Mr. Broder, I had another question for you, and this one is, I'm not going to say it's philosophical, but it's more about the policy behind the law and whether or not you are aware of it, and if can shed some light on me. So why would the Georgia legislature allow providers to enter a lawsuit and with the option to answer in their own name or in the defendant's name, even though coverage is not yet determined?
I think at one point in time in my review of Wallace and Miller, I probably had a cogent answer to that question. I mean, I think the idea was to promote judicial efficiency by allowing the UIM carrier to basically monitor and have an opportunity to depose the plaintiff and understand, whatever the potential causation arguments might be, so that it wouldn't be necessary to have a whole trial and process regarding a verdict against the tortfeasor, then to be followed by presentation of the claim to the UM carrier. It's certainly allowed to do that, but my understanding, or at least seems from my perspective, it promotes efficiency by allowing everything to be dealt with at once. However, that said, the question of whether or not the UIM company breached their contract or whether they engaged in some sort of bad faith associated with that is something that can't happen until after we get some sort of resolution here as to what the verdict is against the tortfeasor. I think it also creates an opportunity for the insurance carrier to address coverage questions. I mean, the typical circumstance you would see is if an insured fails to provide timely notice of an accident. At that point, we can figure out fairly early on, is this a place where we would have coverage or not because you didn't provide notice within your 90 days or whatever the case may be. Again, I don't know that those concerns are necessarily implicated here. I think there certainly is a coverage question, but the coverage question is going to be determined by the testimony that's provided by the plaintiff. It's going to be based off of the language, the express language of the policy that's already been provided in this court's determination as to whether or not it would apply to the circumstances. So going into questions about underwriting standards and the reason why a decision was made or was not made, do not believe is going to be pertinent or useful for this court in deciding what the outcome should be as presented here.
And so, I definitely understand it about the breach of contract issue, but to me, well, UM providers don't always deny coverage and this proceeds to a lawsuit. I'm pretty sure, and I've never done a whole lot of PI work, so, forgive me, I didn't do a whole lot, but doesn't it work like they notify you all of this issue before they send you a lawsuit? And you have to make a decision then whether or not you're going to pay out the policy or
Yes, I mean, there's
say, okay, serve me with a lawsuit, right?
certainly there are typically demands that are made to the UIM carrier for whatever amount of coverage they deem is appropriate. So that is certainly made before the lawsuit happens. Although the question of what are someone's damages and what is the amount is not. I mean, there's still issues that have to go through this process to potentially be determined. And I mean, just sort of foreshadowing for the court, and I think your court has already seen some of this in our prior motion. The particular facts of this accident, and again, this is a little bit beyond sort of the scope of our motion, but I think may be helpful for some context, is this is not a case where the defendant, Artesia White, hit Mr. Chad Murphy with her car or, struck him while he was in another vehicle. The facts here are that Mr. Murphy, I believe his nephew was, they were at a job site and doing some road work. Mr. Murphy's nephew was hit, and the injuries that are being claimed are related to Mr. Chad Murphy, falling down as he stepped out of an excavator to go render some sort of aid. And so because of that, we do have questions about, causation, comparative negligence. I mean, there are other factors here that go into the determination, not necessarily just based on the policy itself as to whether or not coverage should be extended, certainly, or paid out in the amounts of plaintiffs are requesting.
And that's, I'm going to allow Mr. Hudson to give his response, but that's sort of what this comes down to for me, is that when a UM provider has made a decision before the lawsuit is filed that we're not going to pay what the plaintiff is requesting. We decline because we don't think, whatever your thoughts are, I think that's the subject of the discovery. And not necessarily the breach of contract, but I could be wrong. Let's hear what Mr. Hudson has to say.
Thank you, Your Honor. I think you're hitting on some very interesting points. And I think, unfortunately, Mr. Broder is trying to predict what's in my brain and the plaintiff's brain instead of just addressing what's exactly in front of us. This is a motion for a protective order. And the only citation to any case that I heard was one that we cited in our brief. There is zero basis for a protective order here. He has not cited you any. He has not shown you any evidence of bad faith or harassment or anything like that. So at the outset, there's no basis for it. That's why we sought fees with this, because the entire time of this litigation, Farm Bureau is not participated, and we haven't had any remedy. I've tried to schedule this deposition since the beginning of the year, and to this date, I have yet to been provided a date for a deposition. And inherent in what Mr. Broder was telling you is he hasn't even discussed this with Farm Bureau. It's a baseless motion. It's my client's own insurance company that is denying him coverage. They have noticed his deposition to occur in 2 days from now, but yet they will not sit for a deposition. That makes zero sense. There's no law, there's no case, there's no anything to support at all what they're saying. On the contrary, if you look at the cases that we've cited, Your Honor, there's quite a few on the other side of this. You mentioned a little bit about your experience with cases. Unfortunately, I have quite a bit. And this happens a good bit. Most of the time, Your Honor is correct. Coverage is not an issue. So the insurance company can answer, and most of the time they will answer on their own for a period of time, but coverage is not an issue, and they really are riding alongside the tortfeasor. That's not what's going on here. This is a bona fide coverage dispute. This is no different than Farm Bureau filing what's called a declaratory judgment action. I don't know if you're familiar with that. Your Honor has already issued an order in this case clarifying, and rightfully so, that it is my burden to prove coverage in this case, along with liability and all those other things that we'll get to in a minute. I have to prove coverage, which means I have to understand why they're denying coverage. This has nothing to do with breach of contract at all. This has to do with why they are denying coverage and what are the basis for those denials. I don't know it. As we sit here today, I don't know it because Mr. Broder and Farm Bureau have refused to participate in discovery with us. And I detail all of that in our brief. But typically, coverage is not an issue. But here it is. And I cannot imagine if this were just a solely coverage case that Mr. Broder would be asking the court not to allow his client's deposition. That's absurd. I've handled numerous coverage issues. I've never once heard that a defendant can't, or that an insurance company can't be deposed. That's nonsense. Now, also, Mr. Broder himself has told me, and I anticipate he's going to be filing a motion for summary judgment in this case on the issue of coverage. Well, how in the world am I not allowed to figure out what their basis is before they file? He would like to simplify it and say, well, we're going to use these facts and the judge is going to apply the law. Well, it's not that simple. There's more that goes on in coverage cases than just that. Particularly in underinsured motorist coverage cases, there are almost always factual issues to be resolved. And in fact, I anticipate in this case, because you heard Mr. Broder talk about the difference in the factual scenario of this case, that there are going to be factual issues for the jury to resolve which way on coverage. I don't think under any circumstances this case is one that can be resolved on a motion for summary judgment, unless the court grants coverage, which I believe clearly there is. But not only is coverage at issue in this case, we talked a little bit back about Farm Bureau has options. They can participate in they don't have to participate in this case at all. I don't know if your honor knows that. They can sit it out. Or they can defend in the name of the at-fault party, Ms. White. Or they can defend in their own name. And Farm Bureau has decided to defend in its own name. And if you read the case, I believe it's the Moss case I cited you, they can defend in their own name and sometimes not become a named party, but once they contest coverage, they become a named party in the case, and they're subject to all the other rules as everyone else. And Farm Bureau is taking it further. They're participating in the case by noticing my client's deposition. Like, how in the world can they notice my client's deposition but not sit for their own? That is very telling. They filed a motion to dismiss the case, not only on the breach of contract claim, but also on negligence. So they are contesting as a party that Ms. White was negligent and that she caused the injuries to my client. I have to be able to discover those issues. And Mr. Broder also told you Farm Bureau is claiming that my client caused his own injuries, is claiming a host of other things. I've cited all that in the brief to you. But Farm Bureau will be present and a party at all of the depositions. They will be present at any mediation as a party. They will be present at any trial. They will have the right to ask questions. They'll have the right to open and close. They'll have the right to do all the things that any other party does. And so I have to be able to understand their positions, and I have to be able to cross-examine them on their positions. Otherwise, it's unfair to us at trial. I have a party that I have no knowledge of that's going to stand up and attack my client. That is unfair on every level. Now, I'm asking the court to stop this. If Farm Bureau wants to be a party, let's treat them as such. If they don't, today, they can dismiss their answer and they can watch this stuff from the sidelines. But if they're going to be involved and contest coverage in this case, they have to allow me proper discovery. We asked for fees in responding to this case because, like I said, there's not a single basis to support what they're saying. No case law, no nothing. Just what Mr. Broder thinks I'm looking for because of a notice to depose his client. So what is it that Farm Bureau is asking? They're asking to avoid the deposition in total without citing to you any law to support it. Again, they are a party. I cited the Moss case in the brief. And because they are a party, they have to be treated, they're subject to the Civil Practice Act. Everything that any other party is subject to. That's the Kelly versus Harris case cited in the brief. They also noticed our deposition, like I told you. I imagine, and this is what I want the court to think, imagine if the shoe were on the other foot after Farm Bureau has noticed my client's deposition. Imagine I were seeking a protective order to stop Mr. Broder from deposing my client on the very same issues that are contained in our notice. That would be sanctionable. And I would submit to you what Farm Bureau is doing is the very same. Again, they can dismiss their answer if they want, but if they're going to be in the case, they have to be subjected to the same scrutiny that we are. So if there's no basis to outright grant a motion to quash and not sit for deposition while they're still pending as a party in the case, then what are the parameters? The court needs to know that in all of their responsive documents, Your Honor, when we first served the case, we served discovery on them, written discovery, which included admissions, which included interrogatories and requests for production of documents. And I gave Your Honor a little flavor in the brief about what they've done. Well, despite in their answer denying everything, right? And you heard it out of Mr. Broder's mouth. They've denied causation. They've denied liability. They've denied damages. They've denied coverage. They've literally denied everything. Despite denying everything, I asked them about their denials in discovery responses, and they still didn't tell me. I cut and pasted a little flavor of that in the brief, and they basically objected to everything. So I don't know what their support is, what the factual background is for why they're denying the things they are. And like I said, I have to be able to understand that before I'm even able to represent my client. Because they have denied them all, I have to get to the bottom of all of those denials. And we cited in our brief, Your Honor, discovery is broad, like really broad. Even these topics, if you read the case law, I'm not subject, these topics aren't even limiting. I'm entitled to understand when a defendant has put certain things in their pleadings. I'm entitled to cross-examine them about their pleas. I'm entitled to cross-examine them about their statements. The purpose of broad discovery and broad rights to cross-examination is so that we can avoid a surprise at trial, which Farm Bureau will absolutely be there. They don't have the guts to dismiss their answer, because next they would be defending in the name of Miss White, who will probably be in prison, and she's someone who fled from the scene of this crash. So that's the reason why they want to participate. Also, like we talked about, the burden is on me not only to prove liability, damages, all those other things. I have to prove coverage. And I have the right to conduct discovery on that. And like we talked about earlier, and y'all, I've tried one of these cases before. Cases involving coverage, and I cited some of those in the brief to you, they usually involve mixed questions of law and fact. And so there are a host of facts to develop in the case that, we might end up trying the case on the coverage issue. At this juncture, we just don't know. All right. There's no basis for, there is no basis for a protective order. There is no evidence of bad faith or harassment, and the burden is on the person who the discovery was served to produce some evidence of bad cause or some other reason, evidence for why we're seeking the discovery we are. And Your Honor hasn't been given any of that. I'll read page 7 of our brief. Excuse me. Yeah. And this is about, it was interesting to me. I guess the basis for why the topics or were wrong for some reason is that they would be too burdensome for a insurance company to develop a witness. I thought that was particularly rich, given the fact that they've already filed multiple motions and they're intending on taking a deposition of my client in a couple of days. But nonetheless, the fact that it might be onerous or difficult, that is no basis to deny a deposition. Corporate depositions are taken all the time, as are corporate depositions of insurance companies. I cited to you this Hyatt Hotels case, and it says the corporation must prepare the designee to the extent matters are reasonably available, whether from documents, past employees, or other sources. And it's not a defense that it can be time consuming or something like that. That is not the standard in Georgia or anywhere as far as I know. Page 10 of the brief, we cited the on that issue, the QBE insurance case, which kind of, talks about the standards for 30B6 depositions. And it says, Rule 30B6 preparation may be an onerous and burdensome task, but this consequence is merely an obligation that flows from the privilege of using the corporate form to do business. In other words, the fact that it's going to take Mr. Broder a little time to talk to his client and get them ready for a deposition is no reason to quash the entire thing. That would be silly. And that same case says Rule 30b-6 depositions tend to lessen the burden of discovery. So it's actually a tool to move the case forward. And frankly, Your Honor, they didn't produce me any files. And I don't know, other than taking the court's time to file a motion to compel and we go through each of them again, I served a notice to get them to bring them to the deposition so that we could talk about them. I've asked Mr. Broder to prepare a privilege log. He hasn't done a single one. I mean, I don't know what else to do to move the case along. I don't understand when he told you there were less burdensome alternatives. You know, we asked for like the facts and things underlying their denials and all that. And, you know, they produced the policy and he says, we produced the policy and that's enough. But there's case law I cite to Your Honor, like directly on point on this. A corporation doesn't just go, here's our documents, like that's the end of it. They have to be able to stand behind those documents and support it with something. And their testimony around what those documents mean and their interpretation of those documents is critically important, particularly when they're the ones, and Your Honor is right. In this case, they made a determination of coverage well in advance of this lawsuit, well before any lawsuit was filed. And so how we can't question a corporate representative of this company on not only its insurance policy, but any of the other surrounding documents which have to date not been produced, I don't know how you get to the bottom of the coverage issue. It seems to me like Mr. Broder's version of this world is insurance companies deny coverage and you can't do anything about it other than say, go to the court and say they're wrong. You can't really get into the meat of it. That is not the law. I think Your Honor knows that. In fact, a corporate agent may not take the position that its documents state its position. They have to explain their position. That case we cited to you was, it's like a Great American Insurance Company of New York. And then there's this was a Nevada case. We were also told in the brief that the requests were not relevant. We addressed that in the brief. I don't really think we need to rehash that here. We've talked about all the reasons why they're not relevant. A big one, Your Honor, that I think does need to be addressed is that Mr. Broder has claimed that we're just seeking privileged information. And that again flies in the face of everything I've ever learned handling coverage issues. The insurance company doesn't get to deny coverage, especially to its own insured, and then get to step back and go, you can't see anything. That is not the law. In fact, the law is just the opposite. But to begin with, you can't make, and we cited this in the brief, you can't make just a blanket assertion of attorney-client. Like you have to come forward, and the burden is on Mr. Broder, right, to say these are the things that would violate attorney-client privilege. He hasn't done that, not at all. He's just said these requests invariably are going to violate attorney-client privilege. But he hasn't shown why. We don't know what documents exist because he won't produce them. And we don't know if they are privileged or they're not privileged. He hasn't showed, Your Honor, hasn't done anything. But we cited, there's no citations. The burden is on Farm Bureau, and he cited nothing at all. But what we have cited to Your Honor is a series of cases that say the claims files and first party insurance claims, and I included in the exhibits, Your Honor, a reference from the book that Mr. Broder mentioned, Jenkins and Miller, they're the authority on everything insurance in Georgia, says that claims are first party claims. And under that reasoning, the courts have said first party claims, because it's your insurance policy, are not privileged. Like they need to produce it, plain and simple. And they have not. And also the Chandler case, although it is in a different context, the reason why we cited it to Your Honor is because the the main takeaway from the case is that a UM claims file is discoverable. In fact, a court abused its discretion by not ordering it produced. And so whether or not whatever posture we're in does not matter. The fact that they are denying coverage makes that producible, and it's not privileged under any case that I could find. And one certainly has not been cited to us by Mr. Broder. In addition to what I believe is extremely hypocritical about the fact that they are going to depose my client and they're filing motions and they're denying all these things in the case, but they won't also sit for a deposition, is the fact that Mr. Broder himself served written discovery on us, which we responded to appropriately. And I've cited it for your honor in the brief. Almost all of those topics are the very same topics that I would like to discuss with them at their deposition. And had they appropriately responded to discovery, there's a potential that the deposition could be somewhat avoided or at least tailored down. But the fact that they haven't done anything makes it where all of these topics must be explored in that deposition. I do want to briefly, Your Honor, kind of show you, or at least talk about the exhibits that we produced. And I thought I had them pulled up. And go through why I produced them to you, why we attached them to our response. So the first exhibit is their answer. And if you look at, this is the Farm Bureau answer. And by the way, they keep calling themselves unnamed defendant. I don't even know what that is. Can we get them to start calling themselves Farm Bureau? Because that just doesn't make any sense to me. Their answer is Exhibit 1. And you'll see either they deny everything or they have no knowledge of anything. And all these are, things that I need to discuss in their deposition. But their defenses, they even claim venue is improper. Like, that's something I need to discuss in a deposition with them. Or that our claims are barred because of some condition precedent. Like, all of these defenses are what they put in their answer. I didn't ask them to, that's what they've done, but I want Your Honor to see, what their pleadings say, which is what their lawyers say, versus what their people are saying, which we don't know. But we know what their lawyers are saying. Exhibit 2 is the discovery that I served on them. And so Exhibit 3 will be their responses, which typically we get a little more information. But if you look at their responses, like, they literally told us nothing, despite the fact they're denying liability, denying coverage, denying my client was hurt, and then also claiming he hurt himself. I think those responses are pretty telling. Most of them contain objections. And they also, by the way, were not verified up until a couple weeks ago. Exhibit 4 were all the communications I've had beginning almost immediately after I received these discovery responses, asking, hey, where are these responses? Can you verify them? Can you produce more documents? And then there's discussions about, immediately me asking for deposition dates. I had to set the deposition, I believe it was in April, and Mr. Broder couldn't make it, so I put it off. And since that day, I've been asking for more dates. And instead of getting more dates, I had to unilaterally set this date again on the date Mr. Broder was available to depose my client. In other words, they couldn't give me dates for Farm Bureau's deposition, but they could give me dates for my clients. Quite hypocritical, if you ask me. Exhibit 5 is another series of emails along with Mr. Broder's deposition notice of my client. And then Exhibit 6 are the responses to admissions, which is another way that we really tried to nail down the issues in the case. And all Farm Bureau's responses did is create more issues that I need to explore in discovery. Exhibit 7 is the portion of Jenkins and Miller that talks about uninsured motorists being a first party insurance coverage, which makes sense because it's your own insurance coverage. And Exhibit 8 are Farm Bureau's discovery requests to us, which I detail in the brief, involve some of the very same issues and topics and things like that that we want to discuss in the deposition. So I believe the court has a couple options. It can rubber stamp what this insurance company is doing and not require them to sit for a deposition, not require them to respond to discovery, and we just show up or respond to their motions with whatever we have and whatever they feel like they have to tell us. Or Your Honor can stop this, and we can stop coming before Your Honor every time we ask for them to do what the law requires and them to act like a party. Again, if they don't want to be a party, they can dismiss their case today, their answer. I'll sign off on anything they want. But if they're going to show up in 2 days and question my client about every single thing going on in this case, then they need to show up also. Thank you, Your Honor.
All right. Mr. Broder?
Yes, Your Honor. We do have case law cited in our brief. You know, most of the case law addressing this is in that other context that the plaintiff conceded the Chandler case involves, which is a first party claim after a case like this one has resolved, either through a verdict or otherwise, and there is a direct pursuit against the uninsured motorist carrier for denial of those benefits. So certainly in that context, I think it does matter. But that's not the context that we are in, where there's not a pending direct claim for breach of contract against Georgia Farm Bureau. The standard for a protective order is not that we show bad faith or harassment by the plaintiff. It doesn't require some sort of intentional misconduct in order for the court to grant the protective order. I would note, plaintiff's counsel said, oh, if the shoe was on the other foot, there's no way I could file a protective order. Certainly there would be, depending on the questions that were going to be asked and the context in which they're going to be asked. So it's not that we're seeking something unusual here by trying to have the law followed to the extent of appropriate bounds of discovery. Beyond that, with all the talk of the responses to written discovery responses and the answer, defendants and insurance companies are allowed to deny allegations by plaintiffs. There's nothing inappropriate about that. I mean, much of what this case is going to be about is about the burden of proof, which is on the plaintiff. We're not here sitting with a bunch of affirmative defenses. As I understand it, they're going to be an issue in this case. And so the focus of discovery is necessarily going to be on the plaintiff and what their claimed injuries and damages are. Some of the complaints about the scheduling, I think it was pretty clear that there was going to be need for the court's intervention regarding the scope of whatever any deposition might be, regardless of what date that it was set on. So we're not here just trying not to provide dates or be difficult in that regard. The fact of the matter is we're going to have a date that was set so that we can not only get people in line should it go forward, but also seek the court's involvement to make sure that the Georgia Farm Bureau as a defendant is, only having to respond to the discovery that they're lawfully required to. So with that said, Your Honor, we do believe that this is an overreach. We would ask that you grant our motion to quash or otherwise constrain the request to the pertinent issues before the court. Thank you.
All right. I know there are some other attorneys present. I don't know if they are for the other party, or does anybody else need to put anything on record at this time?
Your Honor, I'm here on behalf of Ms. White. I do not have anything to put on the record. Thank you, though.
And can you state your name?
Yes, Your
I
Honor.
see it, but Just,
Michael Brown here for defendant White.
okay.
And Your Honor, my name is Craig White. I'm representing the other UIM carrier, Utica National Insurance and Republic Franklin Insurance Company. I do not have anything to add to the argument. Thank you.
Okay. All right, thank you, gentlemen. I'm going to, I know the sensitive time nature of this, I'm going to have an order done by the end of the day. I've already started reviewing things. And so I'm going to work on that right now. I don't have anything else to do today.
Thank you, Your Honor. I really appreciate that.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
That concludes this matter. You all are excused.
All right.
All right, ladies.
All right, Judge.
All right, Miss Maynard, I'm gonna go ahead and get send you that link right now, because if I don't, I'll forget about it.
Thank you, Judge. I appreciate it.
If you have any trouble opening it, well, I don't know when they're going to, it'll be saved on the server, right? My hearings are,
Okay.
I don't record them per se, but they are saved to the YouTube server. And so if you have any issues opening it, if a, transcript needs to be created, then let me know and we can go from there. But when you get it, if you could just try to see if you can open it up then, and if not, then we may need to take other steps now while everything's fresh in my head anyway.
Okay. Okay.
All right. All right. Thank you all. Have a good day.
Thank you.